on for child support orders. Is that correct?
It's on for final dissolution. Mr. Dillon has already been found in default, and we were set on the Thursday docket both on August 24th and August 31st. It got set over because of the commissioner having a conflict. Our child support order and worksheets have been sent to the court. I believe the mother has sent the other final pleadings over as well.
All right. Is Alicia Poole Dillon present?
Yes, I'm right here.
Okay. It looks like I have findings and conclusions, a final divorce order, a parenting plan, a child support worksheet, and a child support order. And I have reviewed those. And it looks like there was a finding of default. Based on that, I will enter all orders. It does ask though, I'm going to ask Ms. Powers this question. So on the findings and conclusions about a marriage, it says, and just because you may know off the top of your head, it says the court is signed. Oh, never mind. Signed final child support order and worksheets today. So it will be today. Everything will be entered on the same day.
Perfect.
All right. So I am signing off on all of these and I will get them to the clerk as soon as we are done with docket this morning.
Thank you.
All right. Thank you.
I'm here.
Thank you.
Thank you. Good luck. Good morning.
Morning.
We have Curtis Hart present.
I just sent him a text because I didn't see his name on the waiting.
Oh, and we have a GAL here too. So I'll recall that case, but hopefully it won't be too long. Thank you, Ms. Hart.
Thank you.
Mr. Anagnostou, do you have a matter on?
Yes, Your Honor. Number one on the docket, Shauna Ray, court-appointed counsel for Miss Ray. There's a guardianship case, a companion guardianship case that's going to be heard next week. And these two cases kind of follow each other along. This is of course, the family law case. I don't see Mr. Chappelle unless he's on the phone. Part of the issue is Mallory Smith was the guardian ad litem in both the guardianship case and in this family law case. And she's no longer a guardian ad litem.
Well, she just filed an order for an extension in GAL fees. It looks like that was entered August 18th of this year.
Okay.
So, I don't know. I don't see Miss Smith here.
Right.
But given that order, it makes me think she may still be finishing this case.
Okay.
So, and you said the guardianship matter is on, is it on for a trial next week or?
No, it's on for a review hearing.
Okay. Do we need to find out what's going on in that before we move forward in here?
No, I think at this point, the family law case is kind of on hold until the guardianship case is resolved, the third party request, because at this point, neither of the parents have placement of the children with them.
Okay. Well, I can set this over 1 week or I can set it over 3 weeks or longer, I guess. I don't have anybody in the waiting room. I don't hear a response from Jason Chappell or Chappelle. Star 6 to unmute. Yeah,
why don't we do 3 weeks? That way we can know what happens next week, and potentially if I need to file pleadings, that will give me time to file documents in this action.
So how about the 27th at 9 a.m.?
Sounds good.
Thank you. All right. Thank you. All right. Thank you.
And Casey Looney on behalf of the state for child support, Your Honor.
All right. Thank you. So I have that this was on for presentation of orders. I do have orders, and it looks as though Commissioner Carmi was adopting the GAL's recommendation and asked Mr. Rooney to prepare orders. And also I have the child support worksheets in order. I've reviewed all that. Have all parties been able to review these orders?
Yes, Your Honor.
All right. Any any concerns with me entering these now. They do appear to conform with the adoption of the GAL report that Commissioner Carmi ruled on last hearing. All right. I have reviewed the GAL report. I reviewed the minutes from the last meeting, so I will sign off on Mr. Rooney's parenting plan and Miss Looney's proposed child support worksheet and the child support order.
Thank you, Your Honor.
All right,
Your
thank
Honor,
you.
Your Honor, one more thing,
Sure.
if it's all right. I just wanted to let the courtroom know that I did get a sexual advocate for me and my daughter, and I have signed up for the classes. It was supposed to start yesterday, but they had an emergency, and so it got pushed out a week. So it won't start till next week.
All right. I appreciate you sharing that, and I hope that is a good program for you and your child.
Okay. And,
All right. All right. Good luck to you. Thank you. On for
Thank
a GAL compliance review and interim report. So do we have Joseph Becerra and Ashley Becerra?
I'm here, Your Honor.
Thank you, Mr. Becerra. Do I have Ashley Taylor, Courtney Becerra present? Star 6 to unmute on telephone. All right, not hearing a response. I do have Mr. Lawrence here, who's the appointed guardian ad litem. And I guess, Mr. Lawrence, have you been able to meet with the parties and get your process started?
Yes, Your Honor. I met with Joe on the 18th of August, and I met with Ashley the very end of August. There are a lot of allegations by both parties in this matter. I'm going to be, or I have requested documents from both parties, and I'm going to be speaking with collateral witnesses about allegations that have come up. And so it's going to be a pretty involved matter, but both parties have been cooperative.
All right. I see that we have, looks like a final review for December 6th. Is that time frame going to work for you, Mr. Lawrence?
I believe it will, Your Honor.
All right. Mr. Becerra, any other things of concern at this point, or?
No.
All right. Well, I appreciate your presence and your cooperation with the GAL. So we'll pass this to December 6th, 2023 for final GAL report.
All right. Thank you.
All right. Thank you. Good luck. I just saw Mr. Hart pop into the waiting room, and it looks like we have Ms. Kale now.
I apologize, Your Honor. I was in a courtroom in Clark County as well, so I'm hopping around a little bit today.
That's okay. That's okay. So Mr. Hart, I just called your case, and I'm sorry, I saw you just connected to audio. So I just announced your case and called the number since I saw that you joined us here and that we had Miss Kale present. So this is 17-300-46408. We're on for a review hearing. I did review the minutes from the 9th of August, and it sounds like things are going really well. The parties are working well together. Hopefully that's continued, but there was some concerns about health of grandmother and her ability to be able to care for the child during visitations. And I think that's what we were set on for review for today. If that's wrong, please let me know. That's what I deduced from the minutes.
Your Honor, for the most part, you're correct. The one caveat to it is that kiddo is actually living with grandma at the time, unless that has changed since I spoke with the Hart family last. And so the concern was, is that still going to be, there were some tests that needed to be done. I sent Mr. Hart the ROI. I have not received the test back, which was part of the court's requirement that I be able to review what the test was, what the test results for grandma. So I haven't yet heard what's kind of come of all that testing and if this is still going to be a good place for kiddo to be.
You're muted, Mr. Hart.
All right. So I did get my mom to sign that ROI. I think I might have washed it before I uploaded it. Did I send it to you? Okay.
No.
Then I'll just go get her to re-sign it. She doesn't have Alzheimer's. She does have a mild cognitive issue, but it said that there was no sign of Alzheimer's. I did have her sign the paper. I washed it before I uploaded it. So I'll do that today. Like when we're done here, I'll walk back over there and get that done because I can just reprint it out from the last email.
Okay.
And I very much apologize for being late.
That's okay. I appreciate that. If we get that, Ms. Kale within the next couple days, and you're able to confirm that the placement is sufficient, I guess, what are our next steps, or what if there's any, do we need additional reviews? Do you want to set another review for a few weeks out to ensure that we have what we need and the placement is appropriate?
That's my final concern in this matter. These two parents have done an absolutely wonderful job of working together, and Eric's seems to be doing very, very well, going back and forth between them. So for me in my position within this case, I think making sure that grandma can still caretake the way that it seems good for everybody involved. And really, I mean, ultimately that's going to come down to Mr. Hart and his family feeling like that's still a good fit. The last piece of the puzzle is just, should grandma not be able to be a good place for kiddo to be? Is there a space in Mr. Hart's home for Eric to be permanently when he's not in visitation with mom? And I believe those overnight visits are on their way. They're just around the corner, I think. Is that true, Miss Hart? I think we're getting there timing wise.
Yeah. Mr. Hart and I have talked, and we're thinking the beginning of October to switch to the unsupervised. So like through September, we'll continue doing the daytime supervised with my friend Melissa. And then beginning of October, switch to daytime weekend visits with me. And then starting November, go ahead and start the overnight, which Eric is just more than excited about. So,
Yeah.
And I've actually visited with Grandma Hart in person a couple times now. And, you know, she seems like she's doing really well to me. So at least from my viewpoint, it doesn't seem like there's any issues or concerns there as far as Eric staying there at this time.
Okay.
Your Honor, if the family feels like the situation is safe and good for Eric and people feel like we're on a healthy track, I don't know that we need another review. I think these two parents are doing a really wonderful job together. And I think that what's going on is really positive. Eric's in mental health treatment. Parents are doing all this great communication. I'm comfortable if you're comfortable, I think is what I'm saying.
Okay. Would you still want the ROI to be completed though?
I would like to see the test. Yeah, I would like to see yeah.
All right. Well, I in reading the minutes, and I saw some notes from Commissioner Carmi. She was just more than impressed by how well the parties have been able to kind of work together, figure out a plan, put the child in front of everybody else's needs and wants. And that's amazing to hear. We don't see that as often as we'd like. So I really appreciate that. So I want to commend both parties for that. And Mr. Hart, if you're willing to get that ROI done and over to Ms. Kale, I'm fine not setting a further review if both parties are comfortable with the plan that you have moving forward. Obviously, you can always return if something were to pop up, but if you don't, I'm fine not setting one.
Okay. Yeah, I'll go back and get that done today.
Ms. Hart.
I have a question. So
Sure.
Mr. Hart and I have been working together on getting a parenting plan together. And I turned it over to him yesterday for his final review of it and hopefully signatures. What do we do about that? Do we just go ahead and turn all that stuff in and then get another court date, or should we set a review for that final parenting plan today?
If you have a final parenting plan that you're both agreed to, you both think this is the best final parenting plan, you can just submit that what they call ex parte, meaning you don't need to do it with a court date. And then a judicial officer would just review it and sign off on that. And then the clerk would let you know that it's been signed and you can get a copy of it. So you can do that without having to come back to court.
Awesome.
Okay. All right. All right. Well, I'm glad to hear everything as well. Best of luck to both of you. I will not set another review and look forward to getting that final plan entered.
Thank you very much.
I will
Right.
file a motion for discharge as well, Your Honor, and congratulations to the Harts.
I'm here.
All right. Thank you.
I'm here.
Thank you. Good luck. All right. So this is a review of a contempt. And from what I could gather from the last hearing, it was set over to today to see if there were efforts made towards payment. And if there were, then the contempt would be denied. If not, the contempt would be granted. So I know that there was a kind of a change in how the parties were going to address childcare. So back child's care would still be owed, but moving forward, it would kind of change. So where are we at?
So I just got my job. I got my first check on the 31st and I had to pay rent. My next check is in a week, and including this month, I owe him $350. So I was going to pay the $350 on my next check, which is coming up on not this Friday, but the next Friday, so about a week and a half. And I was going to pay him the $350 to get completely caught up with back child support and then start on making payments for the child care. But I just got a job like 3 weeks ago.
Okay. Mr. Smiley?
Yes, so we have not communicated on any of that. When we initially started this case at our last court date, she had that job already and said to the court she started a child support case through making payments, I think. The only case they have on record is 290-239, which was July of 2022, which is closed. So I am unsure of how she's making payments to me. That's what she said in court that she was going to be doing.
I called Thurston County Courthouse or Thurston County Child Support Division, and they said that there is no open case, including this case that we're working on right now. They said that there was no open case, and I can make payments through them, but it's not required because this case is not like court ordered to do that. And so since me and him had agreed that I would just pay him directly, whether it be cash or Venmo or whatever, because we agreed to that and the court signed off, there wasn't any like thing to pay like through Child Support Division. But I did call them and they said that I can pay through them just so that it's documented and that I paid and everything. But when I did the last court date, I did not have this job yet. I found out the next day after the court date that I did get the job, and then I started, I think 3 days after that or 2 days after that, one of the two. But I didn't have this job yet until after this court date was already happening. And so now I'm just on track I paid my rent on time, and now I'm on track to start paying him. I'm going to pay him the $350 on this check, and then every check after that, which I get paid every 2 weeks. So every check after that, I was going to pay him $100.
So September 15th would be your next payday? That's the Friday after this one.
So 30. Yes, the 15th, possibly the 14th if I get paid a little early. This time I got paid on a Thursday, so I don't know if that's regular or what, but either the 14th or the 15th, yes.
And you indicated last hearing that there was a $50 payment plan that was set up. Is that for?
That is for child support. So it is the
Separate.
5th every month. She pays $50 for child support.
Okay.
And then as of right now, it's bi-weekly for child care. So 2 weeks ago, I paid $400 for child care. Today, I pay another $300 for child care, unless she's able to pay her half. She's supposed to pay half of it. So 2 weeks ago was $200, and then this week is $150 that she would owe.
Is that the $350 she's referring to then, but to pay you for or is that separate?
I'm uncertain. I would like clarification on that.
So where's the $350 number coming from, Miss Smiley?
So the $350 is the $50 in child support since when I've paid last. Child care is completely separate, and I still have to pay back on that as well.
I'm a little confused on that statement, Your Honor. The last time she paid me child support was in February. So where's that $50 since the last time you paid?
That's what I'm
saying. I want to make
February, January, March, April, May, June, July, August,
September.
Now it's September. Okay, so now I would owe $400 as of the 5th.
And that's just in child support. And then the back there was the almost $800. I think it was $780 something that we talked about that you owed late fees.
Yes. Well,
it would be the $200 plus the $150 as well now that is on that I've paid this month.
Yes. And so I have to still work on paying you back on the child care, but the child support would be $400, and then I'd be paid up until the 5th of next month.
Okay. So is my math, and arguably my math isn't always completely accurate, but so we're at $400 owing in child support and $1,130 owed in child care expenses.
As of
that would include the $200 and $150 that Mr. Smiley just spoke of. All right. It does, I do see in the minutes that you said that you were still seeking employment at the last hearing. I'm glad to hear that you have a job. Here's what I'm gonna do. Are you able to make a $400 payment next Friday? To Mr. Smiley?
I can try my best. I know that I've already set aside 350, so for sure 350 is already planned to be taken out of my check. But if I can do 4, then I would absolutely do 4.
Okay, because we're 1530 behind. All right, here's what I'm gonna do. I'm gonna order that next Friday, the 15th, you make a minimum $350 payment to Mr. Smiley. If you can do 400, that would be ideal. And we're gonna review this on the 27th of September at 9 o'clock in the morning to ensure that that payment is made and see what plan you have to try to catch up with that. Because that essentially would catch you almost up with child support. Well, if you paid 400, which catch you up with child support, you're still would then be 1100 approximately behind in childcare. And it's not fair for Mr. Smiley to have to pay that all on his own. So what kind of plan you have moving forward, or if there's another payment you can potentially make on the 29th at your next pay period, just to sort of try to supplement and get that back support done. If on the 27th, you haven't made the minimum of $350 payment and you don't have a plan to start repaying the remainder, I'm going to make a finding of contempt. I'm going to give you another opportunity since you're now employed to make that payment. I'm going to order that on the 15th. There's a minimum payment of $350 to Mr. Smiley. If that doesn't happen, you're going to be found in contempt. And then if there may be additional fines and fees assessed against you.
Okay.
All right. Okay. So we'll set this to the 27th at 9 a.m.
Thank you so much.
All right. Good luck.
Good
Morning.
Thank you.
And do we have Luis Kozar? *6 unmute on a telephone.
Yes, I'm here, Your Honor.
Okay, thank you very much. We are on for an interim GAL report, and I do see Ms. Turnbull. Good morning.
Good morning.
All right, have the parties been in contact with you? Things progressing?
Yes, both parties have been in contact, and I've had an opportunity to interview both parties. Mr. Kozar has said that he will follow through with the substance abuse evaluation and the domestic violence evaluation that was ordered previously by the court that he had not completed. And so that is in progress. I do think that we need to address some boundaries around the visitation of Jackson and Mr. Kozar. There seems to be some conflict and some issues around that I think that we could smooth out. And so currently Mr. Kozar is on supervised visitation. He was previously doing that with his mom. There's been some issues there, and he's asked to have that supervised visitation with his grandmother. She has agreed. Ms. Lawrence has agreed to that, although she has not met grandma yet, and I think would like to. This last Sunday, visitation happened at grandma's house, and so I think one of the requests would be that visitation be scheduled and set on a specific day and time every week so that it's not changing. That grandma be the one to come out and pick up Jackson from the car and bring the one at the beginning of the exchange, and also to bring Jackson out to the car to Ms. Lawrence at the end of the exchange, so that there's minimal contact between Mr. Kozar and Ms. Lawrence during the visitation. And so there's not discussion throughout the week about what time and place the visitation is going to happen, what day. It's set in stone. And then there's no contact during the exchange. And I think that it would be helpful for these parents to have My Family Wizard or the Talking Parents app. I think if there's going to be any sort of video or phone contact between Jackson and Dad, it would be helpful to do it through my through the Talking Parents app so that that's recorded.
Okay.
And I don't know if I've missed anything. I think the parents can weigh in on that.
All right. Miss Lawrence, guess the three main points that the GAL brought up, do you think visitation can be set kind of at a regular date and time and be the same every week?
Yeah, he asked if it could be Sunday at 1, and I agreed on that. So if he wants to keep it at, that's fine with me.
And Mr. Kozar, Sunday at 1 p.m. every week works for you?
Yeah, that should be fine. And then I also wanted to bring up that I missed one of the visitations the week before last week we just had because of the situation with my mother. And so I was wondering if I could have some sort of makeup time, as well as the last time I just visited with him this last weekend. My grandma and I both took note that she dropped Jackson off about 10 minutes late and then came about 8 minutes early to pick him up. So I didn't even get him the full 2 hours as well when I did see him this last time. So I was just wondering if there's any makeup time I could get, or if there's anything I could do to call or see him any more than the 2 hours that I've been seeing him.
Okay. I'll address that. Let's just go one at a time. So let's set visitation for weekly Sunday at 1 p.m. and let's keep that. If for some reason Mr. Kozar cannot make that work, I'm gonna ask that the parties use either Our Family Wizard or Talking Parents. Both of those, I believe, you can download for free and use for free. Ms. Turnbull, do you know that if if Talking Parents requires payment to utilize the phone portion or the communication
I believe
portion?
I believe there's a payment requirement for that function. But I think that there's enough conflict here that it may be helpful if the parties are willing.
All right.
So Talking Parents app, I already downloaded it. It's the free one. The other one, you have to pay $99. I already sent him an invitation, but he hasn't accepted it.
Yeah, I got it yesterday, but I worked overtime, so I didn't get home until about 8 o'clock last night and fell right asleep. So yeah, I didn't get a chance to reply. My apologies.
So I Googled it. So it looks to me like the version of Talking Parents that allows video and voice calls to be made with recording is $25 a month. But they also have a 30-day free trial. There is a $0 or a free version that records all the messaging, and the messaging is secure and allows you to share calendars and different important dates like that. So, and then frankly, the standard subscription that's $10 a month allows you to make payments and share PDF reports, which I don't know, that doesn't seem worth it to pay $9 versus the $0. You can receive calls on the standard subscription and receive video calls as well, but they're not recorded. So, and Our Family Wizard, I think, is relatively similar. It has a free version. And then it also has a paid version, but I want to think for some reason that it's, I feel like it's an annual fee and not a monthly fee, but I could be wrong. Okay, but so I guess at the very least, Mr. Kozar, if you could, and I muted you because there was a bunch of feedback. That's not your fault, but just don't talk to me without unmuting yourself. Mr. Kozar, at the very least, download the free version, because that'll allow you to at least communicate and put things on a calendar, and allows Ms. Lawrence to put things on the calendar that are important. So get that downloaded. I guess, Ms. Turnbull, are your concerns great enough about the communications that are happening that you feel that the any audio and video conversations between dad and child should be recorded, at least for a period of time?
I'm more concerned about between dad and mom.
Okay.
And I think that the conversations, when they happen between dad and child, get diverted to between dad and mom.
Thank you, Ms. Kale. Ms. Kale, one of our other GALs, is indicating Our Family Wizard does an annual fee. So I was right about that, but they also offer very accessible fee waivers. So she would recommend Our Family Wizard. So I'd ask both parties to get Our Family Wizard. And I'm on their website right now, and it says getting started, and it says for families. And then one of the first things you can click on is the fee waiver program. So I'd ask the parties to look into that, download that, start using Our Family Wizard to communicate with one another. We'll set regular visitations for Sunday at 1 p.m. and those are for 2 hours. Miss Lawrence, I'll just remind you that 2 hours is 2 hours. So if you're 10 minutes late, then pick them up 10 minutes late. So there's a full 2 hours with dad. Do the parties have any concerns with grandma being the one to come out to the car, get the child, take the child back in, do that back and forth?
I would prefer that.
Mr. Kozar, I again asked you to unmute now. Any concern with that happening?
No, that's totally 100% fine with me.
Okay. I don't know the situation that resulted in you not having a visit. Sounds like a few weeks ago. I don't know if someone was at fault for that or what issue with your mother that you're referring to. So do you want to tell me a little bit more about that?
It's just, and it was even the week before that. My mom was seeming to have almost like an issue with me having the visit day for some reason. But then the week before this one just happened, I had my visit and I was waiting there actually 30 minutes before she even came home, just because I was just wanting to be there, to do my visit with Jackson. And I think she was just having a bad day or whatnot. And I ended up asking a question related to this, and I don't remember what it was, but it was just like a simple question related to all this court matter happening. And she just had like a freak out moment, and she was kind of going off on me. And she told me several times that I don't need to have my visitations there anymore. And then her last thing was, you can just leave. You don't need to have your visit here anymore. And so I just went to my truck. I called Haley right away and let her know my mom wasn't letting me have the visit there. And I asked if there was anything I could do to make up for it, or if I could just, if anything, like around her family, her for 2 hours or whatnot. So I was just completely missing my time, and she didn't want to hear it, and she just hung up on me. So then I just kind of ended up missing my time that week, unfortunately. So.
Okay. Thank you for expanding on that. Ms. Turnbull, any position there or any information about that you're aware of?
Yeah, I have not spoken to his mom, but I did speak with Ms. Lawrence about it, who talked to the mom, and it sounds like the conflict was between Mr. Kozar and his mother, and I think his mother maybe has a different perspective on what the conflict was and how that went. So he didn't get his visit because of the conflict and the choices that the two of them made around that. It had nothing to do with Ms. Lawrence, and so I'll leave it at that.
Okay. All right. I think what we're going to do, I think there's better defined time. So you should get 2 hours every Sunday at 1, and it shouldn't be shortened for any reason unless there's exigent circumstances or communication beforehand. So, and that communication needs to go through the Our Family Wizard app. Both parties need to get that downloaded and on board. And I would highly suggest that you look through the fee waiver so you can get the upgraded version of Our Family Wizard. Again, like I said, there is a free version, but the paid version is much better. And it has, as I stated, an annual fee, and Ms. Kale helped point out, versus a kind of a high monthly fee. So let's get that started, and let's start using that to communicate. Sundays, 1 o'clock, 2 hours. I'm not going to, at this point, I'm not going to award any makeup time for Mr. Kozar, but I am asking Ms. Lawrence moving forward to ensure that Mr. Kozar gets the full 2 hour time period.
Okay.
Looks like we have a final review for the 8th of November. Any parties or any need for another review before that November 8th date?
Not that I'm aware of.
Yeah.
All right.
I just want to make sure that we have Mr. Kozar's evaluations in hand prior, so that I can review those before the before that date and incorporate them into my report.
And he's agreed to get that evaluation, correct, Mr. Kozar?
Yeah, I have it's scheduled for, I believe it's, I still have to schedule for the drug abuse, I believe, is the only thing I have to schedule, but I have the other thing going on September. It's already scheduled for this month.
Okay, well, just make sure that you keep Ms. Turnbull in the loop on that and get any ROIs signed so she can access those reports. Okay.
Okay, and so the wizard, that one app you're saying, it's a requirement for us to use that now?
Yes.
Okay.
Okay. And then we will review this again on November 8th, 2023. Obviously, if there's any issues between now and then, the parties are free to note it back up on the docket. All right.
It's just me.
Okay, good luck.
He has a motion for default that I filed because he's not participating. So.
All right. Did you file paperwork?
I did on a Thursday of last week, resubmitted for child support, as the judge previously told me that I had to have a legal reason to request lesser amount than what the court would appoint. I looked at RCW 2619-075, and I couldn't find anything on there that pertains to both myself and Mr. Fletcher. So I adjusted the amount to what the court would calculate at the $798.15.
Okay. It looks like the orders are in the courtroom. That's why I'm not finding them right here. The clerk has the orders. I'm not in the courtroom, as you can probably tell. So I do see the order of default. I'm looking back at I don't have those orders in front of me. Hopefully you can answer this question for me. Is there, so what is the amount that's being requested?
The amount that he and I had agreed upon verbally was $500. And so that's what I had originally put in the paperwork. And I didn't realize that it was going to create an obstacle, obviously. But after reviewing the RCW and not finding any, as the last judge said, legal reason for deviation from the court appointed calculations, I went back in on Thursday to the courthouse and refiled all that paperwork at the $798.15.
Okay.
The previous judge was concerned that it was almost a $300 deviation. And so I fixed it.
Okay. All right. I will, and did you file both the child support worksheet and the child support order?
Yeah, everything should be 100%. I went over it with a court facilitator.
Perfect.
Beginning of August, and she went over everything with me, and I had my last court date trial date on the 30th of August, when I spoke to the gentleman before, and he just told me that was the only thing that I had left to fix, I guess, if you want to call it that.
All right, well, perfect. The clerk is confirming that she has both the worksheet and the order, so I will sign those and file those as soon as we're done here this morning.
Okay, and so does that mean that the divorce is done and I don't have to do anything else?
I guess one more time, I'm going to ask the clerk. So do you also have the final dissolution paperwork? I'm assuming.
Yes, I have findings and conclusions about marriage, the final decree, the final parenting plan, the final child support worksheets, and the final child support order.
Perfect. Thank you, Tiffany. So yes, as soon as I sign those and get them to the clerk, then everything is over and done with. I would imagine that tomorrow afternoon, Thursday morning at the latest, you'd be able to come in to the clerk's office and get copies of those if you wish.
Okay, that's perfect. I have tomorrow off, so I'll be able to go in there. I appreciate your guys' time. Thank you so much.
No worries. Good luck to you. All right.
Thank you so much. You too.
All right. Thank you.
Yes, Your Honor, I'm here.
All right. Thank you very much. Do we have Jacob? Am I saying his last name right? Wyand?
Yes.
All right.
He's the phone number at the bottom of the 275.
*6 would unmute you if you're on a telephone.
And Casey Linney on behalf of the state as well, Your Honor.
Thank you very much.
There are some jurisdictional issues and additional issues that I may be able to clarify if Your Honor would like.
I would like, I just want to make sure that we do have Jacob Wyand at the, I know Miss Despain is indicating that's his phone number. *6 unmutes you on a telephone. Okay, but,
Can you hear me now?
I can, yes. Okay, you're Jacob
All right.
Wyand?
Yes, I am.
Okay, perfect. Thank you. Miss Looney, thank you very much. What can you tell me?
Thank you, Your Honor. This case has been a little complicated. So the state did enter a notice of appearance because the child is receiving TANF here in Washington, but has only been here since the end of April. So there was no jurisdiction to do a parenting plan. In further review of the case, we also have discovered that there is not legal parentage established, so we cannot enter a parenting plan until that piece is completed. So at this time, what the state is doing is that we are moving forward with a parentage case in this matter. We'll be filing a separate case and the parents will be receiving paperwork regarding that. But at this time, we have no ability to move forward on this case.
Okay, I did note that there was a set over for a UCCJEA conference.
That has not occurred.
I was just going to say, I don't believe it's occurred because I see nothing in the file regarding that.
To the best of my understanding, Your Honor, Oregon has not responded.
Okay.
Your Honor, I did reach out to a case manager in Oregon, and she said that she was going to push for that, but she doesn't know the results of it yet. So obviously they haven't addressed that.
Okay. And Miss Looney, when do you anticipate the state filing your case?
We are in the process of doing that paperwork now, Your Honor. So we should be doing the parentage case in the next few weeks.
So if we just set this for kind of a trailing review to either the 27th or the 4th, or
it would take longer than that to complete our case, and we should be filing the paperwork and getting it to the parents in the next few weeks. The issue would be is that the child has not been in Washington State for 6 months until the end of October. But again, we would need to do parentage before we can move forward with any sort of parenting plan. Because we do not have Mr. Wyand as the legal parent of the child at this time. There's no birth certificate with his name on it.
Okay. So how about we set a review out to November?
That would probably be more appropriate, Your Honor.
Okay. So Mr. Spain and Mr. Wyand, I'm going to set a review in this case to November 15th, 2023, 9 o'clock a.m. That will be a review of this case that was filed for the parenting plan and child support. So Miss Looney was very eloquent in basically stating that we don't have at this point the ability to enter a parenting plan with a few different things. The child not established as a resident here at this point in time, and no confirmation of final parentage of the child. So there's going to be another action that the state's going to put forward that will hopefully resolve that issue. And so this matter, really, we can't do anything on this matter until that is completed. So I'm going to set this for November 15th, 2023 at 9 o'clock a.m. Sounds like you're about to get some paperwork from the state. Please make sure you follow up with that. And so that process can get started. And hopefully when we come back on the 15th, we'll know exactly where we're at.
Thank you, Your Honor.
Your Honor, I haven't seen my son since April 27th. Ms. Despain hasn't given me any visitation with my son. I haven't seen him for like 5 months. Could you suggest me to be able to see him?
I have no authority to do that because I don't know that you're the father.
All right.
So I
am the father. All right, I'm gonna need to get a lawyer then for this. Like,
I always suggest attorneys are a really good resource. Additionally, there's Mondays between noon and 2. We have attorneys that volunteer their time at the courthouse on the second floor that you can stop by and see if you can get any advice and relay the information about your case to them. So that's every Monday from noon to 2.
Okay, so am I able to see my son though? Like, I mean, Mr. Spain will not let me see or talk to my son at all.
As I stated, I have no authority to force her to do that at this time because there's no legal connection between you and the child that's been established in Washington. So I can't force her to allow you to see him. If she wants to let you see him, then that's up to her at this point until you're established as a father in the state of Washington. I can't force her to let you see the child.
All right, I have no clue where my child's located or at either. I have no clue where he's staying or anything.
I can't answer the question any further than I already did. So we're going to set the review out, but please, if you please seek out legal counsel or at least get a consultation. And as I stated, there's volunteer attorneys that are present Mondays from 12 to 2 at the courthouse on the second floor.
I'm here, ma'am. Okay, all right, thank you.
Okay, good. All right, good luck. I was going to say afternoon, but I guess it's still morning. Good morning.
Here as well.
All right, thank you, folks. I do have a boatload of paperwork here. It looks like the final paperwork in this matter. And it is on for today for me to enter these orders. Are there any questions or concerns at this point about these orders?
One question I do have is Mrs. Zimmerman and I both have come to the agreement on no support. I don't know how that works in Your Honor's eyes, or how that works out. But we just kind of want to move forward in our lives.
So in the plan is it looks like it's a 50-50 plan.
Yes, ma'am.
And there's no significant real significant difference in income. And it looks like there's a 50-50 share of any additional expenses. Is that correct?
Yeah. Oh, sorry.
Oh, there's a 60-40, I guess, for uninsured medical expenses. But otherwise, it looks like it's equal proportionate share. The child's not receiving any TANF or other state benefits at this point?
As far as I'm aware of, they just received food stamps, SNAP benefit.
Ms. Zimmerman, any is that accurate? There's no TANF benefits at this point?
Yes, Your Honor.
Okay. All right. Okay, I'm going to sign these documents. I'll get them to the clerk as soon as we're done this morning. You can probably get copies of these by tomorrow afternoon from the clerk's office if you wish to have copies. Probably no later than Thursday, but you should be able to get them tomorrow afternoon. I will get them filed with the clerk as soon as I'm done with the docket this morning.
Thank you, Your Honor.
All right, good luck to you both.
Your Honor, I'm sorry, I stepped away from one. I was just informed that there may be a possibility that one of the children or the child involved is on TANF benefits. Can I confirm whether that is accurate?
Sure, they both indicated none of the children are on TANF. I asked.
All right, thank you, Your Honor.
I mean, and I don't, unless you have, do you have anything that says otherwise?
Hold on, my assistant just let me know. She is checking into that. I'm sorry, Your Honor, we're not able to confirm. So at this time, I will just be stepping away. I apologize for the interruption.
No, that's okay. All right, I will finish signing these orders. I guess just know that if there is information that one of the child is on state benefits, there could be, the state can raise the issue at child court, bring that back before the court, but you would get communication from them as part of that.
Understood.
So, but I'm signing off on all your orders at this point.
All right. Well, I appreciate
Good luck to you both. Let me see here. All right. I do have an order, a restraining order here.
Yes, ma'am.
Okay, so it looks like, sorry, this is not my regular docket, so I just want to confirm where we have. I have a motion and declaration for an ex parte restraining order that was filed on the 24th of August and a temporary restraining order that was entered, it looks like, by Judge Basher on the same day, the 24th of August. And it was set to today's date for the petitioner to be served. We have both parties present. So Ms. Gibson, I see that so I reviewed your motion for ex parte restraining order, and I see that I have a final restraining order here that was provided. And here. And I also saw that there was some evidence that you filed in support of this of this order. Mr. Kilpula, were you provided or served with the evidence that was submitted to the court?
I was.
All right. And Ms. Gibson, since this is your motion, I'm going to ask you to relay any information that you want me to know for the request for a restraining order.
I actually had a question about it because I was looking over it and I noticed that they had whited out 2 sections where I had put other orders that should be put in place for mediation purposes. And I was wondering what that was about.
Okay, which one was that a different? What
was
whited out on what form?
Let me pull it up real quick. It was on the form for the immediate restraining order ex parte, and it was on the 3rd page. It was on number 10. I had selected other. They had whited that section out, as well as the following page, number 14, for other immediate orders. They whited that section out too.
Well, my assumption would be that that wasn't part of what the judge was comfortable ordering based on the information that was provided. So that's why it was excluded.
Okay, I was just curious what that was about.
That would just be my guess.
Okay.
Obviously, I am only seeing the order that was entered, so those portions are whited out from what I'm looking at. So I don't know what other orders were requested there.
Okay. So when I had filed, I originally had 22 pages that I had printed. There were like 4 pages that weren't accepted because they weren't readable with how they printed. But I do have additional screenshots and such to back up the reasoning why I want a protection order. I just do not feel safe when he is talking to me or to our child, and how he interacts with her. It sends off a bunch of different red flags for me. And that's why I put the restraining order in, because I just do not feel that either her or I are safe in his presence unsupervised.
Okay. Is there anything besides what you filed or any other concerns? It sounds like there's allegations of some alcohol.
Yes, so I do have some people filling out witness statements that will be notarized in case I do need to submit that to the court of his alcohol and Adderall abuse. Sorry, I kind of mixed those words together. While driving with our child in the car. So I'll have, if you do need that, I'll have that submitted as well as soon as possible.
Okay. Mr. Kilpula, obviously this impacts you pretty greatly, the request for this restraining order and the temporary restraining order that's entered. Are you prepared to move forward? Are there witnesses that you want to offer? What is your position on this restraining order?
Well, I would like to start off by saying that I object to all the claims Patricia has made on the basis of hearsay, and the fact there is no proof, let alone evidence presented for the things she's claimed. I cannot prove that I did not say something, just as Patricia cannot prove that I did. Okay. Some of the claims she has made can be disproven, though. For everything else, I can only state the truth from my side of the story. I want to make it clear that I only object to a restraining order that inhibits Jana's right to have equal and frequent interaction with me. I can't change how Patricia feels, but I'm a good father. I have not threatened nor harmed Jana or Patricia. I've always had Jana's best interest in mind, and actually all of the evidence that she provided proves that I have wanted that from the very beginning. So there are things that can be proven that she is not telling the truth about, like me punching holes in walls and doors. I openly, I want police to come in here and investigate the whole house. There are no holes in any of my walls or doors. I couldn't even punch a hole through my walls because they're lath and plaster. I would break my hand. She said that I kicked a door open, and that's why she has a bruise on her thigh. I'm a 200-pound man. I do construction. If I kicked a door open, it would be off its hinges, or there'd be damage to it. It would cause more damage to her than a tiny bruise. Okay, so She claims that I call her all the time. Well, I would like to see her call log. I can show my call log, right? There are claims that have no founding that she is trying to submit. And again, I would just want to make it clear, she can get a restraining order. I can't change how she feels, but it should not inhibit Jana's ability to have equal and frequent interaction with me, because that's what's in her best interest. I would also like that there isn't some sort of testimony that is biased, right? I mean, I could get testimony from my best friend like she had done, but if that's not viable in court, because it's my best friend, it's not a non-biased entity, right? I could get testimony from my mother, my best friend, but that's inadequate, in my opinion.
Your Honor, I would like to state, I do have witnesses to him hitting the door open and putting a hole in the wall. My brother was there that night. He witnessed the whole interaction. That was at 2 a.m. with my daughter in my hands. I was trying to put her to bed. It was right around Thanksgiving or Christmas time. And if I do need to, I will contact our old apartment, because I'm sure they have taken pictures of the door to our previous bedroom, and that had holes all over it. And my parents have witnessed the state of that door. So I'll check in with them and see if they have any pictures, but I was not lying about any of those occasions.
Okay, so I guess here's another question. How, a lot of these text messages are frankly a little bit hard to read. I do see some that are, it appears that they may be between you and Mr. Kilpala. I don't, but some of them are from months and months ago. And let me see here. Is there a temporary parenting plan in place in this case?
The mediation lady did call me regarding that, and she didn't know how to proceed until this hearing regarding the restraining order and everything. She was supposed to contact me yesterday with more information, but she hasn't gotten a hold of me yet.
Okay, so other than, and it sounds like, so the door incident was last fall, is that fair? And you said that your child was in your arms during that?
Yeah, he had been trying to talk to me, and I was trying to put our daughter to bed, and I had repeatedly expressed that I cannot continue the conversation. I'm trying to put her to sleep. And he was arguing that she didn't want to go to sleep, even though it was 2 a.m. and that she should be awake and kept up. And I had disagreed, and I had gone to multiple different rooms across the house while my brother was present. And Christian just proceeded to get more aggravated with my responses, and it escalated from that point. And my brother did have to calm him down after he smacked the wall with his hand, and it put a hole in the wall. And then when I told him he could not come into the room while I was putting her to sleep until he had calmed down, he had forcibly opened the door.
All right. And then there was an allegation that he was in essentially intoxicated around the child or with the child. Can you explain that to me?
Yes. So while my brother was staying with us, I had allowed Christian to go to the store with Jana. And when they came back, she was not in her seat. She was in the front seat with him from the grocery store. I was extremely upset by that. And then there were other occasions where I had asked him not to drink before driving on long periods of drives, like to my parents, because they live 4 hours away, and he would disregard my wishes and drink while driving. And I would end up eventually getting him to swap seats with me when he would get tired enough, and I would proceed driving.
And what kind of time frame is that allegation? When was that?
Well, the last time we went up to my parents was for New Year's. So last New Year's. Well, this year, but the last New Year's.
Okay, so have there been any more recent incidents where?
No, because I do not let him drive her. Whenever we have had any visitation, I have been the one to do transportation.
Okay, and what type of visitations have been occurring?
He got to see her for Father's Day, and I was sick the week before Father's Day, but he got to see her the weekend, like 2 weeks before Father's Day as well on that weekend. I'll have to pull them up and write them all down, but he has been able to see her on a few different occasions and spend some time with her. When I was up at my parents', it would only be a few hours because it's a far commute and he's not allowed on their property. So we'd have to go to like a park and take her for a walk. We have gone to the zoo with her, which was an all-day trip pretty much. But they're all supervised. I don't leave him unattended. And sometimes I do bring a sibling with me.
And do you reside locally or somewhere else?
I now reside in the Vancouver area because the Bellingham to Vancouver or Kelso area was too much of a toll on my vehicle.
Okay. All right, and I do see that there was an order transferring this case to mediation, and you indicated that because of this recent filing of a restraining order, there's mediation basically is on hold. Is that fair?
Yeah, that's what she said to me. She just didn't know how to proceed and wanted to get more information before discussing anything further.
Okay. And Mr. Kilpala, are you still agreeable to mediation at this time, or?
You know, she hasn't really done a whole lot to work with me on any of this, but I'm still open to mediation.
Okay. All right. Well, here's what I'm going to do. I reviewed the motion for an ex parte restraining order. Reviewed the copies of evidence here. I frankly, so it's preponderance of the evidence, which means more likely than not. So 51% to 49%. And clearly there seems like there were some major concerns. It doesn't sound to me like any of those are extremely recent. Does that mean that it's not something the court's considering? No, it doesn't mean that, but a lot of these are older concerns. And have there been any concerns with Ms. Gibson with the recent the visitation that occurred around Father's Day and Father's Day?
I don't believe it was Father's Day, but 2 weekends prior, he had alcohol cans within reach of her on the ground that need to be taken care of and cleaned up. Like, none of that should be in reach of her. Because what he does on his own time is his own time. I just don't want it around Jana. But those were concerns of mine.
Okay. I'm not.
For the record, I would like to say that I take drug tests for my job. It's mandated every couple of months, and we get randoms. I haven't drank alcohol for about 3 months now. I haven't taken my ADHD medication for over 4 months now, and I can prove that. I mean, I just a couple of weeks ago, and I was going to submit it with the court, I took a drug test on my own time. I mean, I can take as many drug tests as needed to show that I don't do these things. So
okay.
That
I appreciate that, Mr. Kilpala. And frankly, I would encourage you to submit the results of those recent tests to the court.
Of course.
Here's what I'm going to do. You guys are a little bit in limbo here, so I'm going to do something that probably neither one of you expected to have happen this morning. I'm going to deny the permanent restraining order. I don't find that there's sufficient information here, but clearly there needs to be some parameters that the parties work under. So I do want you to move forward to mediation. So hopefully this will allow for that. In the meantime, I would like to have my pen just ran out. Sorry, finding another one here. I would like Mr. Kilpala to have 2 hours a week. And Ms. Gibson, have you been the one that's been attending those visitations, and are you comfortable doing that? Or is there another mutual party that can supervise those visitations?
Yes, I do have a couple people that said that they could do it if I were uncomfortable.
And I don't have I guess I'm not saying that it has to be you. If you're not comfortable, I understand that.
Yeah.
But if there's someone else that's willing to do that, I want Mr. Kilpula to have 2 hours of supervised visitation. We do have a form that you'll need to get for your visit, whoever is going to supervise. And basically for both parties awareness, that order basically says the child's safety is the most important. And regardless of what happens if I'm friends with one side versus the other, I'm going to report any concerning issues for the safety of the child, that I'm not going to make anything up. I'm not going to try to favor one party over the other. So it's a 1 or 2 page document that you can get on our webpage. Your supervisor, whoever's willing to do it, will need to get that filed. And I think we need to get Mr. Kilpula to have some visitation in the meantime. So I'm going to order that he get 2 hours. I understand that may not happen this week just because of what needs to happen. And obviously once we have a supervisor that's willing to do it, we have to have everybody's schedules and availability. So, but I think so this is the week of the 4th. So the week of the 11th should be the start for this. So by next week, we need to have a supervisor that's willing. If for some reason there isn't a supervisor willing, then I will authorize professional supervision. I don't know how long the wait list is for those. And that's obviously something that you would have to pay, but I'm highly encouraging the parties to find what we call a non-professional supervisor. Those 2 hours a week should start no later than the week of September 11th, upon agreement of the parties for date and time. Ms. Gibson, if you're not comfortable working directly with Mr. Kilpula, then whomever the supervisor that is chosen can be the go-between. Mr. Kilpula just needs to know who that is so that he can communicate his schedule and availability with that individual. Does that make sense?
And what form was it that I need to get? What is it called?
Let me see if I can pull it up, because let's see here. It's called the Oath of the Lay Supervisor. And it's a form that I believe we have available. And it basically just says that I agree to supervise this child between these parents, and that I won't violate any rules, and I will, remain within eyesight and hearing distance, and to supervise and protect the child's safety and report any concerns. So it's like a 2-page document.
Okay.
And we'll get that on board. So additionally, there is, and you may have heard me discuss it earlier, there's a few different applications that you can download on your phones to communicate and put things on the calendar between the two of you to set up things. And so Our Family Wizard and Talking Parents both have a free version that allows you to text back and forth and to set up a calendar. So if that would be an easier way to work between the parties about, so if Mr. Kilpula can update in the calendar, here's my availability for the coming week based on my work schedule. And then that allows you to just look and work with your supervisor to schedule visitation. So then there really doesn't have to be direct communication.
Okay.
I would encourage that as well.
Okay.
Sorry, go ahead, Ms. Gibson. What was that?
There were 2 apps, Our Family Wizard and what?
Talking Parents. So as long as they're both perfectly acceptable. One of them, Our Family Wizard, frankly, is usually what's more recommended than Talking Parents. And it does have a fee waiver. So if you want to upgrade to the fancier version of it, you can apply to have the fee to pay, to pay for that app waived. But I don't, frankly, with what we're doing right now, kind of in an interim basis, I don't know that you need to get the paid version. It just is a way to keep track of messages back and forth and kind of utilize a schedule that you can both put your information in for availability.
Okay.
Okay. And then give mediation a shot. Obviously, if that doesn't work, return here and we'll get a more kind of finalized plan in place for you folks, and or get you set for trial if we can't come to some kind of an agreement.
Okay.
All right.
All right. Thank you.
All right. Good luck to you.
Thank you. Bye.
Oh,
Nope. did you have a question?
Yeah, I was going to ask which apps she would prefer to use.
Oh, I'm still here.
Let's just go with Our Family Wizard. That way there's no concerns. So both parties download Our Family Wizard.
Yeah, that's
there's a way to invite the other person, and then you can link up through that and then share text messages and the calendar information.
Okay.
Okay, and do I need to file another motion for mandatory mediation, or is
My hope would be no. If they were waiting to see what was going on with the temporary versus final or the restraining order, with it going away now, you should be able to just resume mediation. If that's not the case, you can, if you both agree that you're still willing to try mediation, then you can enter an agreed order, or you can bring it back before the court.
Okay.
I'm here, Your Honor.
All right. All right. Good luck to you both. All right. Thank you both. Looks like we're here to talk about the results of the UCCJA and to review some orders that may be presented here.
That's correct, Your Honor.
So I have a note that says that this is a Pacific County case and not a Cowlitz County case. All right. And is that your understanding as well, Miss Linden?
No, I was told by the courthouse here that because our son resides with me and I have no way up here, that it should have fallen into Cowlitz.
Okay, who told you that?
I believe the clerk's office when I went to file paperwork. Okay. And I believe I was told by the last judge during the last hearing.
Okay, so that unfortunately, Miss Linden, is not the information that I have. I have that the results of the UCCJA hearing was that this has been determined to be a Pacific County case. So based on the information that I have, the UCCJA conference. Okay, hold on. I'm getting some information from the clerk.
Your Honor, I do have a question. If it's in Pacific County, how do I get paperwork there? Because I do not drive. And the transportation I do have has work.
Hold on one second, Miss Linden. Okay, thank you for your patience. So there is a scheduled UCCJA. It has not occurred yet. So, and there is concern because there is an active Pacific County case that's dealing with the same parties as well. So based on the information that I just received, the commissioner in Pacific County is working with our commissioner. We should have results of that by the 27th. So unfortunately, I'm going to set this over to the 27th of September at 9 a.m. to review that UCCJA, the results of that.
Your Honor, if I may also input into the courts, I stay up to date on my child support, and I do have proof that I am the father. Miss Linden is not allowed me any interaction. Next month is his birthday. Do I have a chance at all to see him for that at least?
Well, I would definitely, I would hope so, but at this point, because we don't know who has jurisdiction, I can't enter any definitive orders in your case. But if we're reviewing it and it sounds like they've already started communicating to get that hearing set. So my hope is that we'll be ready to go on the 27th, and hopefully we'll get some visitation scheduled or arranged and at least a temporary parenting plan in place at that point here, unless it's a Pacific County case. If it's a Pacific County case, then it can get noted on and scheduled there as quickly as you are able to do that.
That was my next question was, what is the way I can file during this procedure right now? Because without no temporary order and being held up with this, I'm not able to proceed to show movement forward. Miss Linden has been the one to hold this up forever. If I may enter as well, the last judge we saw in Pacific County was Don Rickner, and he had court ordered she can respond via certified mail. And that's how she was supposed to respond to Pacific County without having to drive all the way out there.
So that, Ms. Linden, should answer your question that you asked me earlier. It sounds like, and so if it's approved for certified mail, great. I would double check there and you can respond that way. You don't have to drive to Pacific County. To answer your question, Mr. Adams, I can't give you legal advice, but what I would say is if there's any responses that you want to file, I would file them in both cases at this point. So that way there's a record in both, and then whichever one is deemed to have jurisdiction, your stuff will be there and ready to go.
Okay, sounds good.
All right,
Thank you,
so the 27th at 9 a.m. All right, good luck.
Your Honor, I have something to say.
Okay,
He
Ms.
has
Lynn.
been in town multiple times. I have told him I'm not stopping him from seeing his son. I only requested that he doesn't take him out of Cowlitz because of how often he is threatening that he is going to take him and never bring him back.
Your Honor, if I may input.
Okay, no, we're not getting into this discussion in this docket. Clearly there's some issues, but if she's saying that you can visit him, then that can happen without a court order. So if you feel like you can work together, great, but we're not getting into that at this point. Okay, so we'll be back on the 27th at 9 a.m.
Thank you.
I'm here.
All right. Good morning. I keep wanting to say afternoon. And it looks, I have Zach Bissig. Can you hear us, Mr. Bissig?
Yes, I can.
Okay, perfect. So, I have a temporary family law order that's been submitted by Ms. Gibson along with, a temporary parenting plan. Mr. Bissig, have you been provided those proposed orders?
Yes, I have, and I have responded with a declaration.
Was that the one that was filed on the 1st?
It was filed last Friday. Yeah, the 1st.
Hold on here. All right, is this y'all's first appearance in court on this matter?
Yes, Your Honor.
Okay. All right, just give me one moment. All right, and this is a petition just for legal separation, not dissolution. Is that correct?
Yes, and a parenting plan too.
And I do not agree to the legal separation. I want to be divorced, not legally separated. And also, Your Honor, I did not receive anything for a response from Mr. Bissig.
Mr. Bissig, did you serve Ms. Gibson with your response?
Yes, my legal advisor told me I could mail it to her, so I did that.
All right, I don't have, okay, a couple different things. I don't have a declaration and confirmation of service. I don't have anything that the court stated that there was an agreement to a service beyond either direct service. So normally there needs to be an order that the court grants for service by mail. You can't just mail someone something and consider that service unless the court authorizes that.
That's on Mr. Bissig's part, not on mine, correct, Your Honor?
Well, if you didn't receive the stuff from the 1st, then there's no confirmation of service in the file for anything that was filed on the 1st.
Oh, just wanted to make sure. Thank you.
So I don't know who told you that's okay. It is okay if the court allows you to or authorizes a service by mail. All right. I hate having to do this, but this is what I'm going to do. I'm going to, I think it's important for the court to have all the information to make a decision. So I have two options right now. I can either disregard everything that was filed on the 1st, which obviously would be, would probably not in Mr. Bissig's best interest, or I can require him to serve Ms. Gibson with all the information that was filed. So that looks like it was 10 pages of text messages and photographs and a declaration affidavit that was provided and signed, and there's some attachments to that, and set this over 1 week to the 13th. So that's what I'm going to do. So Mr. Bissig, you need to serve those on her personally, not you directly. It needs to be a non-party to the case, and file proof of service. And then we'll come back on the 13th to hear the matter and get temporary orders entered. Okay. And I do, for the record, have both a proposed parenting plan from Mr. Bissig and a proposed parenting plan from Ms. Gibson. Those will, I'll ask the clerk to retain those, so the court has those for our hearing next week. So you don't need to refile those unless there's something about them that you want to change between now and next week. Okay, so Mr. Gibson, if you don't serve her those documents and provide proof of the service, then next week the court's just going to move forward without considering those documents. Okay.
Okay, Your Honor.
All right. So set it over to the 13th of September at 9 a.m.
Thank you, Your Honor.
Thank you.
Should ask to make sure she's going to be somebody to be served.
All right. And Madam Clerk, do we have a new Zoom for the next hearing, next docket?
Yes, Your Honor, you do. Also, I believe